Rossi, I know you know a lot about this. You're one of the 500 plus prosecutors that filed that letter with respect to the Mueller report. But let me ask you a question, Gene. Let me play devil's advocate here a little bit, because to me, I'm not so on one side of this or the other. I think there's nuances to a lot of this stuff. Is there a valid argument by the president to say, I was complying with a DOJ investigation, or special counsel's investigation, and I felt that it was important to do that, but I was not waiving all sorts of executive privilege in a proceeding that Congress has, which is inherently politicized? Is there a valid argument to make the idea that I can waive, but then I can stop that waiver?
There is an argument that you can waive the privilege for purposes of an investigation that is within an agency. I think there's case law to suggest that. And when the members of his staff, including McGahn et al., were talking to Robert Mueller, it was within a Department of Justice agency. I allowed them to produce documents and to testify or to give information, but I didn't waive. The little fact that violates that privilege is information was given to private attorneys outside the Department of Justice. That's one argument. That's a hole in the argument. But the waiver is a valid counter argument.
Gene, let me ask you. You're a sophisticated guy, and I know you're on top of this issue. I've been asking myself this question. In reality, let's get our faces out of the textbooks and out of the case law and talk about the real world of hard-hitting law. How does Congress enforce this contempt should they do it? What court is going to, and if a court comes back and says you are to produce witnesses or documents and they say no, what happens?
Well, there are four options. One, it's been done very rarely. The Congress can send out the bloodhounds and have the Attorney General arrested and brought to testify.
That'll lead to a firefight in the streets.
Oh, no, I'm just telling you legally, academically. Of course, that will never be done. It's been done maybe once in the last 150 years. Option two is they make a referral criminally to the Department of Justice. That's going nowhere. Right. Number three, they file a civil action getting the court to decide the jump ball. They did that against Eric Holder. They held him in contempt. Civilly, they got a judge to rule that he had to turn over or provide information regarding Operation Fast and Furious. That took years.
Go ahead.
Pardon me?
That took years. Go ahead.
That's what I'm saying. So, but they could try to ask the court in the third option to do an expedited review of the matter.
And what are your thoughts about all of this? And answering the questions, what is the practical basis to do this? Is the rule of law essentially broken down now if in fact, as we anticipate, a court were to order this stuff to be produced? And it's not just with the Mueller report. They are preventing Congress from knowing all sorts of things for other agencies, including the EPA, immigration. They've basically shut down Congress's oversight responsibility. But you know what? I don't see anyone doing anything about it.
I don't either. I mean, that's the point. It's kind of a circus, and there was, as I understand it, some offer to have, for some compromise, but once you've got this whole push of contempt and subpoena of the full report, then the threat was made before that, as we know, which was we're gonna exercise executive privilege, and that happened. And so now I think we need a more organized pushback. I think Congress just needs, it shouldn't be as politicized as it is, because it really is kind of unbelievable that we've gotten to this point. I mean, really unbelievable that we've gotten to this kind of a point. They call it a constitutional crisis, et cetera, when we really need to move on in this country.
Yeah, this is generally a constitutional crisis, and while I'm no fan of the manner in which the president is going about it, I want to ask you guys as former prosecutors what I think is very important. Again, I'm in the middle of these issues. I think the idea that we're going to wait for the Inspector General or any investigation as to how the investigation of the Trump campaign was initiated, and I think we know the answers to these things, but there are people that are objecting to that. I think that this is a worthy thing to make sure our law enforcement officers aren't overreaching, especially with regard to a campaign. So once again, I come down there, and it not only protects the Trump issue, if you will, to make sure we know what happened, but future campaigns down the road. Do you guys see a problem with looking into it, so long as it's not politicized? Gene Rossi.
As long as it's not politicized, you should investigate any tactic of the police. they're not immune. They're not the Pope. They're not infallible. And if there's a possibility that untoward conduct, unprofessional or illegal conduct occurred, you always investigate it, but don't make it political.
And Bremner, let me ask you, are you concerned about the idea that the Attorney General is using the term spying? Now, I think that people won't get, we know very precisely what that means, and we never use that lexicon, that language of spying in an investigation. And Christopher Wray yesterday testified he wouldn't use it. He would use a court-authorized surveillance. What are your thoughts?
Well, I mean, you can call it what you want to call it, but I mean, maybe it's just a more generic term. I mean, there's a lot of problems with all of this. I was just thinking on that whole investigation, some compared it to like Jean Valjean and Javert and Les Miserables. I mean, just endlessly chasing, after somebody. And this is the United States, and I think we have to be really careful about these kinds of investigations, and sometimes we need to investigate the investigation.
Gene Rossi, can you explain to me why James Comey, in your opinion, stood up and gave a press conference without authorization from the DOJ in the Clinton investigation and not only exonerated her, but then went to do something that I think as a prosecutor is a little unusual, went on to excoriate, if you will, personally, the reckless conduct that she engaged in as opposed to keeping it within the confines of criminal law? What's going on there?
Well, first off, I got to tell you, in 1997, I worked on a drug case, organized crime case, with Jim Comey. We overlapped in the Eastern District of Virginia for about 5 years. Here's my comment. On July 5th of 2016, when Jim Comey held that press conference, he violated custom practice in U.S. Attorney's Manual that you keep your mouth shut.
Why did he do it?
I think I agree with the president. I think there was a little bit of the showboat in him. And here's what you can't do. You can't stand up at a national press conference and say, Bob Bianchi, we're not going to charge him for premeditated murder. However, he's a really violent guy, and that's what he did.
Despite the truth of that, Gene Rossi. And Bremner, real quick, explain to me the logic of this. James Comey gets up there. I remember my phone lit up when he reopened the investigation. He kind of got himself in a pickle when he told Congress that I'll come back to you if there's a change. Anthony Weiner later, he now is up there a week before the election saying it's being reopened and very well could have cost votes. Let's be honest here. It cost votes. And on the other side of it, while that's all happening, there's an investigation that the department is doing on the Trump campaign, and that never gets out. If you ask me, you combine those two things, back out with Hillary Clinton, don't release information about the Trump campaign, that if you were to say anything, Comey and those agencies helped Trump.
Right. I mean, when you talk about collusion and fixing an election, right? I mean, by virtue of one being public and the other not being public. It was extreme, extraordinary, and impactful, of course.
Guys, let me ask you real quick. Don McGahn. I mean, now he's kind of like the guy, that's one of the cartoon character that they're pulling the guy on both ends, both arms going back and forth. Right. His lawyers essentially said, look, we're maintaining the status quo. One side's telling us not to release the information. The other side says they want it. I think it was a very deft legal and public relations maneuver by Don McGahn's attorneys, and the right one to say, until a court tells us to do anything right now, we're going to maintain status quo, we're going to keep it like it is until somebody gives us some direction, but stop putting my client in the middle of it. Gene, what do you think? Absolutely,
and for history's sake, the attorney for Don McGahn is William Burke, who's in the Robert Kraft case. He is a top-notch, A-plus attorney.
Yeah, I thought they really balanced those equities really well. And Don McGahn, why would the president allow 30 hours of interviews when he could have probably pretty rightly exerted executive privilege? Why did he do that, knowing what it was that Don McGahn knew?
You know, I've tried to think about that. It may just well be that he thought that Don McGahn would be super loyal, I guess we could say. You know, that he's not going to divulge that kind of information.
Yeah,
right?
yep, absolutely. The kind of guy that you could ask to put something in a file that's not accurate. Ann Bremner, Gene Rossi, couldn't have two better guys than you guys to break that one down. We're covering it all here on the Law and Crime Network, and we got a lot more. We're going to take a break. We'll be right back.